This is Dish and Dirt with Gary Pickren, South Carolina's only podcast dedicated to the real estate agent craft. And now, the host of Dish and Dirt, Gary Pickren.
Greetings and welcome back, everyone, to another episode of Dish and Dirt, the #1 real estate podcast in South Carolina, mind you. I'm your often opinionated but rarely wrong host, Gary Pickren, coming to you from the beautiful downtown Columbia, South Carolina offices of Blair, Cato, Pickren, Castelline, the last week of May 2025. Before we start, I do want to welcome Carson Murray. He's our new closing attorney in Spartanburg. He is a graduate of probably the greatest high school in South Carolina, if not the entire country. Of course, I'm talking about Dorman High School, where I graduated from. Carson comes to us with over 12 years of real estate closing experience, and he has previously worked with a lot of the staff members in our upstate offices, and so they're very familiar with him, as I am sure you are also very familiar with Carson in the upstate. But we are very happy and pleased to have him part of our Blair Cato family in the upstate, and he looks forward to doing a lot of closings for you guys in the Spartanburg area. Now, Carson is, of course, taking over for Steve, who was recently named as a magistrate judge in Bowling Springs. So we're going to miss Steve, but congratulations to him, and very excited to have Carson on board, and think you will enjoy working with him as well. We're also happy to announce that we will have a new Spartanburg office on the west side of town, and we'll announce in the next week or so where that location will be exactly. So pay attention to our social media as well as this podcast to hear more about the new Spartanburg office. But for now, let's go ahead and welcome Carson Murray as our new closing attorney in Spartanburg. Let's go ahead and jump right into our topic today from a telephone call that I received from one of my really good friends in real estate. Called me yesterday. I was driving back home from Spartanburg, and he was lamenting with me over the argument over compensation and whether or not it could be in the contract. And I want to make sure from this day forward that I'm very clear and settle this issue for you guys once and for all about whether or not your real estate commission can be part of a real estate contract. Here's the answer in a nutshell. It is not illegal, nor is it against the settlement, nor is it against the Realtor Code of Ethics for your compensation to be part of the contract. It's not. People keep saying that you can't put it in the contract. It's illegal. It's against the Code of Ethics. That is not true. And I'm going to prove it to you here once and for all today so that you'll have the answer and you can articulate it back to people who are telling you that they can't do it. Let's start first with the legal argument. Is it illegal for your compensation to be part of a contract? Now, when we're talking about compensation in this sense, essentially what we're talking about is the buyer agent compensation, whether or not in a contract we can put in there that the seller is going to pay the buyer agent compensation. The first place we're going to look is legal. So as you all know, you are governed by the Real Estate Code of Law 40-57. There is almost nothing in that statute that relates to you getting paid or your commission. In fact, the word commission is used 186 times in 40-57-10, 186 times. 4 of those 186 times, it refers to the real estate commission, the board that governs you, that disciplines you, that makes sure that you're licensed properly. That is mentioned 174 times. That leaves only 12 times, which is less than 10%, between 5 and 10%, times that it actually refers to compensation for you. Let's talk about what those 12 times are. 2 times, the word compensation is used to define you as a real estate licensee, someone who receives compensation in a real estate transaction. So it's not about you getting paid, it's just defining you. 2 times, it talks about referrals and how you as a real estate agent can take part of your commission and pay that as a referral to an out-of-state agent who's licensed. 1 time, it talks about it in a listing agreement, about how it has to be in the listing agreement. 5 times, it talks about compensation with unlicensed assistants, how you pay an unlicensed assistant. Can they receive commissions? 1 time, it talks about how you may not cause a delay in a real estate transaction over a dispute over a split of a commission. And of course, the 1 time that says the commission may not be involved in a resolution of a dispute between the licensee over the payment or the division of a commission or fee. Basically, the real estate commission has no jurisdiction over your commission disputes. Those are the 12 times I could find. I may have missed one here or there. There are 186 times the word used. And every time I looked, it was about 174 times it was used as a real estate commission and not as a payment of commission for you. So let me be clear on a couple points here. Number 1, the real estate commission, per the statute, has no jurisdiction over payments of commission. I've actually won several cases over at the Real Estate Commission before I was a commissioner, saying that there's no jurisdiction over real estate commissions. And when I mean commissions, I mean your payment. Therefore, you're not going to find it anywhere in the statute 4057 that will talk about whether or not real estate commissions can be included in a contract or not. Moreover, I've never heard anyone argue that by contract law, common law, statutory law, case law, or any other type of law, that there's any prohibition about a buyer's agent commission being included in a contract. There simply is none. So from a legal standpoint, 4057, silent on it. No case law out there that I've ever seen, no statutory law, no other laws that would prohibit it. From a legal standpoint, it is proper, it is okay for a commission to be paid in a contract, for it to be referenced in a contract. You may put in on a legal aspect that the seller agrees to pay the buyer's commission. There's nothing illegal or improper on a legal aspect about that. It does not violate your statute 4057. Real estate commission has no jurisdiction over you about it anyway. It's not a problem. So now let's go ahead and look at it from an ethical standpoint. First of all, we have to understand that the National Association of Realtors is a trade organization. So their rules only apply to its members. Their rules do not apply to non-members. Even if it was to be considered unethical by NAR, it would not apply to non-realtors. So as a realtor, you could not impose your trade association rules on an agent who's not a realtor. Even though you'll see here in a second that even NAR ethical rules do not prohibit you from having commissions dealt with in a contract between the buyer and the seller. So let's look at the Code of Ethics. 17 articles. I've read all of them. I've taught classes on all of them. That's what I teach a class every year on the Code of Ethics for CCRA. Never has this topic about getting paid a commission on the contract ever come up in any of the examples, any of the stories, any of the materials provided by NAR, SCR, CCRA. I've never heard anyone at SCR, CCRA, or NAR say it's unethical. But I have had some agents tell me that they believe it violates Article 16. So let's examine that. Does it violate Article 16 or not? What does Article 16 say? It says realtors shall not engage in any practice or take any action inconsistent with exclusive representation or exclusive brokerage relationship agreements that other realtors have with their clients. What does that have to do with your commission on a contract? Nothing at all. What that has to do with is you interfering with another agent's agency agreement. If Betty Sue is represented by me, you cannot interfere with my agency agreement as long as I'm representing her. That's what this is about. In fact, we have talked about that ad nauseum on Dish and Dirt. I did a podcast on how you can interfere with agency. We talked about it from a builder standpoint, how builder agents interfere with agency and how they shouldn't be doing that, how the real estate commission is opining on that. We've also talked about how you can interfere with agency by simply not asking enough questions. That's what that has to do with. You may not interfere with the agency of another agent. That has nothing to do with how commission is handled in a contract. Agents have espoused this opinion that Article 16 somehow prohibits it. Will reference standard of practice. Now, a standard of practice is not a code of ethics. You have a code of ethics. You have 17 articles. Under each article is a standard of practice. A standard of practice is nothing more than an explanation, gives you further information, but it is not part of the article. It is not the article itself. In fact, the Realtors Association is very clear. You can only be disciplined for violating a code of ethics. You cannot be disciplined for violating a standard of practice. It is just to give you more information. Under Article 16, there are 20 standards of practice, 16-1 all the way through 16-20. I've reviewed all those. There's nothing in there that talks about you getting paid on in a contract or not in the contract. The closest thing that I have been argued to is 16-14 standard of practice. Again, keeping in mind, you cannot be disciplined for a violation of a standard of practice. But what does 16-4 say? It says realtors are free to enter into contractual relationships or to negotiate with sellers, landlord, buyers, tenants, or others who are not subject to an exclusive agreement, but shall not knowingly obligate them to pay more than one commission except with their informed consent. What does that have to do, again, with you getting paid in a contract? What does that have to do with the seller agreeing to pay a buyer's agent's commission and writing that into a contract? Absolutely nothing. So let's look at it. There's 3 points I want to make. Number one, putting in the contract, you are not obligating them to pay more than one commission. They're obligating themselves. So the seller, by signing the contract, they're the ones who are obligating themselves. They don't have to sign the contract. What they're talking about here is if you represent somebody and you sign an agency agreement with compensation to help them buy a house, and then the other agent goes and gets them to sign an agency agreement as well, agreeing to pay them a commission to help find the house, you've obligated now, that second agent's obligated them to pay possibly two commissions for the same house. That's what we're talking about. Second point we have to make is it says without their informed consent. Well, the contract is their informed consent. If they sign the contract, they are consenting. That is their informed consent. Number three, to say because two agents are getting paid by the same party, even with their informed consent, somehow this is being forced upon them is no different than saying, therefore, that broker-to-broker compensation violates the standard of practice. Because under a broker-to-broker compensation model, one person's paying two agents. The listing agent gets money from the seller, and from that money, they pay the buyer's agent. How is that any different? So it's not. But even if it did violate 16-14, you cannot be held in violation of a standard of practice. That's that simple. But let's say you could. Let's say hypothetically you could be held to violate a standard of practice. You have to understand that as of August 2024, everything in the Code of Ethics, everything in how it applies as it relates to compensation changed after the Sitzer settlement. And we're going to talk about that in just a second. So now what I've done is I've established it's not illegal. It's not against your statute, 4057, your licensing law. It's not against any case law or any other law I've ever seen. It's not a violation of the Code of Ethics. Article 16 doesn't apply. 16-14, standard of practice, you can't be held in violation of that. That doesn't apply. So now let's look at it from the settlement aspect. What you have to understand about the settlement, Sitzer Burnett, is the whole world changed for compensation as of August 2020. Two biggest changes. Number one is a buyer's agent could not get compensated unless the buyer themselves is somehow obligated to pay them. If the buyer's not obligated to pay them, then you can't get paid. For example, if I tell my buyer I will charge them $0 for providing the service, and now the seller's agent says I'll pay you 3% for that service, I can't get paid the 3%. I get paid $0. I cannot get paid, period, unless my buyer has somehow obligated themselves to pay me. Secondly, I can't get paid more than my buyer is obligated to pay me. So if I sign a buyer representation agreement for 2%, and the seller is offering 3 or 4%, I can only get 2%. That is a drastic change from prior to Sitzer Burnett. One thing that confuses South Carolina agents is we were one of 15 states. That's right, 15 states that had buyer representation prior to Sitzer Burnett. 35 states did not even have the buyer representation agreement. We were one of 15 states. We were ahead of the curve in this, finally being ahead on something, right? We were ahead of the curve. So that kind of somewhat confuses agents. But you have to understand these NAR rules are written for the country, not for South Carolina only, and that we did have buyer agency where most NAR states, 35 of them, did not have it. And so that makes it a big difference. But now, post-Sitzer, the buyer has to obligate themselves to pay you in order for you to get paid. If you look back prior to Sitzer Burnett, that was not the case. And so if you were interjecting yourself in a contract, you truly were interjecting yourself when there was no obligation on the buyer to pay you. Typically, you were getting paid through the multiple listing service where the listing agent had listed it on the multiple listing service and agreed that they will pay you a percentage of their commission if you bring them a contract. And that's how you got paid. After Sitzer Burnett, that can no longer happen. We now have to have an individual document on every transaction about you getting paid, whether it's a buyer representation agreement or it's a buyer representation agreement and a Form 120 or some other type of documentation that you get paid. That's what changes it all. So prior to Sitzer Burnett, if you wrote into the contract that the seller will pay the buyer's agent commission, you typically were interjecting yourself as a third party. That's different now because of the buyer obligation. When you put it in a contract now, it's because the buyer has an obligation to pay you and the buyer is seeking assistance from the seller to pay it now. Completely different situation. And that change is very important to understand because that's why no issue in the settlement for you to put it in there. Also, what you need to understand is there's no legal prohibition on a third party benefiting from a contract. Third parties often benefit from contracts. Not being a part of the contract, they still may benefit third party wise, and that's perfectly fine. But a third party benefiting might not have the authority to sue on that. But there's no prohibition against a third party benefiting from a contract. As we sit today, because of Sitzer Burnett, there is absolutely no problem with you putting it in a contract because the buyer is 100% obligated to pay you. If they're not obligated to pay you, then you can't get paid. And so what you're doing now, when you are putting it in a contract, you are saying the buyer is obligated to pay this fee. The buyer is asking the seller as part of this transaction to pay it. It's no different than asking the seller to pay closing costs. It's no different than asking the seller to pay for new carpet, to pay for an upgrade or whatever, new appliances, all that stuff. It's no different. They're asking the seller to pay a buyer obligated fee. And that's why it does not violate the settlement. Now, how do we know that? Well, because it's already in the contract. And don't tell me it's not. It 100% is in the contract. It's like trying to tell me you're a little pregnant. Either you're pregnant or you're not. There's no little pregnant about it. And it's the same way here. Either you're in the contract or you're not. And commissions are 100% already in the SCR contract and the CCRA contract and the Hilton Head contract because of this provision. It says sellers allow or agree to allow up to blank dollars of buyer transaction costs to go toward buyer's broker compensation. That's commission. So when you select that the seller will pay $2,000 of concessions, and then you put seller agrees to allow up to $2,000 of buyer transaction costs to go toward buyer broker's compensation, you're saying that $2,000 can go toward your commission. Please explain to me how that is any different than it being in a Form 120, written as a sentence in the paragraph, written as an addendum. How is that any different? In fact, it's probably more because it's actually in the contract in pre-typed language. At least with a Form 120 or an attached document, you're filling it out and attaching it. This concession language is pre-printed and it's in the contract. So please don't tell me, oh, it's concessions. It's not concessions. It flat out says can go toward buyer broker's compensation. That ain't a concession. That's a compensation. That's a commission. In fact, we often argue with Fannie Mae and Freddie Mac when they're getting into these issues as to contributions. When you say your buyer has to contribute at least 3%, we know that it says here that this amount can go toward compensation and it's not a concession. So it is commission, any way you look at it. Other states have also already included this in their contract. Georgia's contract, mind you, already has commission in it. In fact, they have an entire section, a paragraph called compensation to broker. It's 16 lines long. That's how long this paragraph is, talking about the compensation to the broker. In fact, it says compensation of seller's broker and buyer broker, if any, shall be set forth herein or in a separate written agreement. And then it says it should be attached here to the contract. They're making that form, which would be our Form 120. It's a different number in Georgia. They're making it part and parcel of the contract. So don't tell me that somehow the state of Georgia, which is a much bigger state than South Carolina, that all the realtors there are doing it wrong. They don't get it, but somehow you do. You're the one that understands it. I, in fact, went to ChatGTP and I asked, are there any state realtor contracts that have a provision on broker compensation? It came back with 13 states and included Georgia. Now, I have not independently verified that because I can't get access to all of these states' contracts. In fact, if you try to Google Virginia Realtor contract, you have to have a sign-in, you have to be a member of the Realtor Association. So I haven't been able to see it. I'm sure somebody at SCR, CCR could probably get us access to it. But being the fact they named Georgia as one of those that has it, it makes me kind of believe that this is correct. But the bottom line here is Georgia already has it in its contract, commission, and has an entire section on it, compensation to broker. So it's not illegal. It's not against the settlement. It's not unethical. So now let's look at the last issue here. Probably the most important issue, if you ask me. You have a fiduciary duty to your buyer. And that duty, the old car duties as we call them, includes a duty of obedience and a duty of loyalty. Now, I'm not saying you have to do everything your client tells you to do. They ask you to do something that's illegal. You can't do that. But I just told you it's not illegal for you to put it in the contract. So you have a duty when your buyer says, put in the contract that the seller is going to pay your commission. You have a duty of obedience and loyalty to your client to put that in the contract. The Form 120, as I've talked about in other podcasts, is the proper way to do the compensation. Do not do concessions. It creates loan to value issue. It creates all kinds of issues. Put in a Form 120 and attach it as compensation to the contract. It is absolutely nonsensical for agents to say that you cannot tie a Form 120 to the contract. What you're basically telling me that the entire premise of real estate, the whole 40-57, the code of ethics, its primary purpose is one, consumer protection. It's to protect the interests of the consumer. Well, if I'm a buyer and I need the seller to pay my real estate commission to my buyer in order for me to buy the house, and you're telling me you can't do it because of your settlement. How are you complying with your fiduciary duty of obedience and loyalty? And how is that in consumer protection? How is that in the best interest of the consumer? It's not. If I can't tie it in the contract and say, for this contract, you, the seller, also have to agree to pay this compensation that the buyer is obligated to pay. If I can't do that, then I can literally obligate my buyer to buy the house, and independently, the buyer have to pay me the commission without the seller contributing to it if they don't sign the Form 1, which means it could be signed separately or individually. And then I could lock my buyer into having to buy a property and the compensation not be covered. How is that not breaching my fiduciary duty to my client? And how is that not breaching my duty of obedience and loyalty to my client? See, the big issue here is that agents still look at this as somehow it benefits you. And perhaps pre-Sitzer Burnett, it was a benefit because let's say that the listing in the MLS was paying you 2% and you wanted 3%. So you put that in the contract saying the seller is going to pay my other 1%. Sure, that was a benefit to you because more than likely your buyer was not obligated to pay you. Back in the day, you would get that buyer representation agreement signed, and oftentimes it would put 0 for the amount that the buyer was obligated to pay you. Or it would say, I will get my money from the listing agent. I won't come to you. So there was no obligation. But that's changed here today because it doesn't benefit you. It benefits your buyer. Your buyer is the one who's obligated to pay you. Your buyer, therefore, is asking the seller to pay it. This is Catchmark speak. This is what Catchmark tries to say, is that every time you get paid and how you get paid is solely for your benefit. That's not true here. The buyer is obligated to pay you this money. The buyer getting the seller to pay it in the contract benefits the seller. Sure, you're a third party benefit of that, but the benefit is to the buyer because the buyer doesn't have to pay it. The buyer is contractually obligated to pay you, so it benefits the buyer. Do not fall into this Michael Catchmark speak. This is how he talks all the time, that the agent benefits by putting it in the contract. The true beneficiary of that is the buyer, because the buyer no longer is on the hook to pay you. Now, the proper way of doing this is to put it in the contract with an attached Form 120. And I would say some language similar to this. Buyer is obligated to pay brokerage ABC the following amount for representation of the purchase of this property. The seller hereby agreed to pay buyer's obligation to broker ABC as part of this contract. So you're saying straight out, this is an obligation of the buyer, and the seller's agreed on buyer's benefit to pay this obligation. I would not go in the contract and say, seller agrees to pay buyer broker 6%, 3%, 2%. I wouldn't put that in there because it makes it look like that's for your benefit. So when you're asking for this, putting it in the contract, putting in a Form 120, putting it as an addendum, buyer is obligated to pay brokerage ABC the amount of X for representation of the purchase of the property. The seller has agreed to pay buyer's obligation to broker ABC as part of this contract. Personally, I do this in a Form 120. I attach it to the contract. I believe you're going to see a movement nationwide in the next 3 or 4 months in which pretty much all the contracts are going to put compensation in them. I think you will see that across the country, that compensation will become part of the contract. Frankly, it should always have been from day one. I don't blame the realtors for not getting that. We've all been working our way through it. No one has known exactly how to handle this, and everybody's had to pivot. I've had to pivot on some of my positions and opinions on this. As we learn more, as it's come into being, it's come into how we're using it, we all now know what to expect. So this should be part of the contract. It's not illegal. It's not unethical. It doesn't violate the settlement, and the Realtors Association is not out there telling people not to do it. They're not doing that. You're going to see it changed, in my opinion, very soon. All right, that is our show for today. If you like us, please share us, subscribe to us, and tell all the other real estate agents about us, because that's how we became the #1 real estate podcast in South Carolina, is because of great people like you liking our show, sharing it, and telling others about it. Y'all come back and see me again next week for another episode of Dish and Dirt. Y'all take care now.